হ্যালো ভিউয়ার্স, ওয়েলকাম টু মাই চ্যানেল। আজকে আমরা জানি হাইকোর্টে মাননীয় বিচারপতি অমৃতা সিনহার বেঞ্চে এসএলএসটি সংক্রান্ত একটা গুরুত্বপূর্ণ কেস ছিল, যেটা হচ্ছে এই যে 10 মার্কস সেটা কি বাতিল করা হবে সেটাও ছিল, এবং 10 মার্কস সেটা ইন্টারভিউয়ের আগে অ্যাড হবে না পরে অ্যাড হবে, দুটো কেসই এখানে ছিল। তাছাড়া আগের দিন যেটা ছিল যে 11-12 ভার্সেস 9-10 ইন সার্ভিস, সেটাও কিন্তু এই 12 তারিখেই কিন্তু পোস্টপন করা হয়েছিল। তো আজকে আমরা এই ভিডিওতে শুধুমাত্র যে এসএলএসটি 10 মার্কস টিচিং এক্সপিরিয়েন্সের 10 মার্কস অ্যাড হবে না ক্যান্সেল হবে সেইটা, এবং যদিও অ্যাড হয় তাহলে সেটা টিচিং এক্সপিরিয়েন্সের মার্কসটা ইন্টারভিউর আগে না পরে, সেইটা নিয়ে আজকে আমরা ভিডিওতে আলোচনা করব। এবং আজকের যে টোটাল কেসের যে সারাংশ সেইটা নিয়ে আমরা আলোচনা করব, এবং এই ডিটেলস ভিডিও আমরা ভিডিও শেষে আপলোড করে দেবো, অ্যাটাচ করা থাকবে, আপনারা চাইলে সেটা দেখতে পারেন। তো এখানে যেটা বোঝা গেল যে টিচিং এক্সপিরিয়েন্সের 10 মার্কস, এখানে আমরা যেটা বারবার মানে কে আর এল, এই যে দুটো পয়েন্ট, এই দুটো পয়েন্ট এবং যে একাডেমিক এবং একাডেমিক্সের যে কনফিউশন সেটাও কিন্তু আজকে কোর্টে উঠে এলো, ঠিক আছে। এবং কে আর এলে এই যে দুটো পয়েন্টের যে কন্ট্রাডিক্ট করছে, যে একটাতে বলছে টিচিং এক্সপিরিয়েন্স ইন্টারভিউয়ের আগে দেওয়া হবে, যদি তাই হয় তাহলে এল পয়েন্টে এসে আবার বলছে যে মেরিট লিস্ট করার সময় আবার টিচিং এক্সপিরিয়েন্সের মার্কস নিয়ে মেরিট লিস্ট হবে, অর্থাৎ সেই অনুযায়ী টিচিং এক্সপিরিয়েন্সের মার্কস কিন্তু টুয়াইস অ্যাড হয়ে যাবে। তাহলে মার্কস যেটা 100 মার্কসের হওয়া উচিত সেটা 110 মার্কস হয়ে যাবে। এরকম কিন্তু ফ্রেশারদের পক্ষে যিনি আইনজীবী ছিলেন তিনি কিন্তু আর্গুমেন্ট করেছেন যে দুবার তো আর টিচিং এক্সপিরিয়েন্সের মার্কস অ্যাড করা যায় না। তাছাড়া আরও অনেক আর্গুমেন্ট ফ্রেশারদের তরফ থেকে করা হয়েছে, এবং যেটা এসএসসির তরফ থেকে বা বাকি যারা ইন সার্ভিস টিচার তাদের যে সমস্ত আইনজীবী ছিল তারা যে সমস্ত আর্গুমেন্ট করেছে, তাদের পক্ষে বারবার একটা বলা হয়েছে যে যেহেতু কোনো একটা রিক্রুটমেন্ট প্রসেসে সবাই যেটা মানে এক্সপিরিয়েন্স যারা তাদেরকেই বেশি প্রেফারেন্স দেওয়া উচিত, এটাই বারবার বলার কথা, বলে বোঝানোর চেষ্টা হয়েছে যে যারা এক্সপিরিয়েন্সড সবসময় তারা এক্সপিরিয়েন্স টিচার হলে স্টুডেন্টরা ভালো শিখবে, এরকম অনেক কিছু, যে এক্সপিরিয়েন্স যারা তাদেরকে বেশি প্রেফারেন্স দেওয়া উচিত। এবং যে এখানে ক্রোনোলজির কথা বলা হয়েছে যে 1, 2, 3, 4 অনুযায়ী যদি দেখা হয় তো প্রথমে রিটেন টেস্ট, দেন টিচিং এক্সপিরিয়েন্স, এবং রিটেন টেস্ট এবং একাডেমিকের দুটো পার্টের কথা এখানে বারবার কনফিউশনে উঠেছে, এ এবং বি, সেইগুলো নিয়ে টোটাল 80 মার্কসের উপর কিন্তু এখানে ইন্টারভিউ লিস্ট বানানোর কথা বলা হয়েছে। এবং এখানে দুটো ক্যাটাগরিতে ভাগ করে দেওয়া হয়েছে, যারা উইথ এক্সপিরিয়েন্স আর উইথআউট এক্সপিরিয়েন্স। তো এইটা সম্পর্কে অমৃতা সিনহা বারবার কিন্তু এখানে এটাকে আটকানোর চেষ্টা করেছে, অপোজ করেছেন যে না, তা কেন, দুটো ক্যাটাগরিতে কেন, এখানে ডিসক্রিমিনেশন বা ডিস্টিংগুইশ করা ঠিক নয়। তো অমৃতা সিনহার ম্যাডামের বক্তব্য শুনলাম, কিন্তু ফ্রেশারদের পক্ষে তিনি বলতে চেয়েছেন, এবং তিনি এই কথাটা বলতে চেয়েছেন যে টিচিং এক্সপিরিয়েন্স যদি আগেই দিয়ে দেওয়া হয় তাহলে কিন্তু ফ্রেশার ক্যান্ডিডেটরা একজনও চাকরি পাওয়ার চান্স খুবই কম। কারণ সেখানে তিনি এটাও কিন্তু ফিগারটাও জানতে চেয়েছেন যে কতজনকেই টিচিং এক্সপিরিয়েন্সের মার্কস দেওয়া হবে। তো 2016 যারা ইন সার্ভিস আছে তারা তো মার্কসটা পাবেই। তাছাড়া আজকে যেটা শুনানির সময় একজন আর্গুমেন্ট করার সময় এই ফিগারটা বললেন যে 2000 মতন ক্যান্ডিডেট যারা সেন্ট্রাল গভর্নমেন্টের চাকরি করে তারা অ্যাপিল করেছে অ্যাজ এ এক্সপিরিয়েন্স হোল্ডার হিসাবে, আর 1000 ক্যান্ডিডেট যারা কন্ট্রাকচুয়াল টিচার, ওয়েস্ট বেঙ্গলের যে সমস্ত ইনস্টিটিউশন আছে কন্ট্রাকচুয়াল বেসিসে যারা কাজ করে তারাও কিন্তু 10 মার্কসের পাওয়ার জন্য অ্যাজ এ টিচিং এক্সপিরিয়েন্স হোল্ডার কিন্তু এখানে অ্যাপ্লাই করেছে। অর্থাৎ তাদের 3000 ফিগার জানা গেল, আর 2016 ক্যান্ডিডেট তো আছেই। এগুলো টোটাল ফিগার যারা এই 10 মার্কসটা টিচিং এক্সপিরিয়েন্সের পেতে চলেছে। এছাড়া একটা ঘটনা যেটা ঘটলো যে প্রথমেই কিন্তু 10 মার্কস ক্যান্সেলের যে ব্যাপারটা সেটা কিন্তু উঠেছেন। এখানে মামলাকারীদের পক্ষে, অর্থাৎ এখানে ইন সার্ভিসদের পক্ষে খুবই একটা ভালো আইনজীবী ছিলেন, যেটা দেখলাম মেনকা গুরুস্বামী, খুব দারুণ আর্গুমেন্ট করেছেন। এবং সেখান থেকে তিনি যেটা বলতে চাইলেন, এই সেম টপিক কিন্তু পেন্ডিং আছে সুপ্রিম কোর্টে, যেটা রায় হবে 24শে নভেম্বর। সেই জন্যে কিন্তু মাননীয় বিচারপতি অমৃতা সিনহা কিন্তু ওই জিনিসটাকে এখন হোল্ড করলেন যে 24 তারিখে যেহেতু সুপ্রিম কোর্টের রায় আছে এবং সেম ম্যাটার পেন্ডিং আছে, তো এখন সেই সম্পর্কে কোনো ইন্টারফেয়ার হাইকোর্ট করতে চাইছে না। 24 তারিখ সুপ্রিম কোর্ট এই ম্যাটার নিয়ে কোনো কী রায় দেয় দেখা যাক। যদি ইয়েস হয় তাহলে ইয়েস, আর যদি নো হয় তারপরে নোয়ের পর যদি নো হয় তাহলে তার কিছু বলার নেই। আর যদি এক্সপিরিয়েন্স অ্যাড হয়, ইয়েস হয়, তাহলে তখন কোন জায়গাতে এক্সপিরিয়েন্স ইন্টারভিউর আগে না পরে সেইটা নিয়ে আমরা আলোচনা করব। এইটা কিন্তু মাননীয় বিচারপতি অমৃতা সিনহা বলতে চেয়েছেন। অর্থাৎ যে ক্যান্সেলের কেসটা সেটা কিন্তু আজকের মতন পুরোপুরিভাবে প্রথমেই কিন্তু সেটা পোস্টপন্ডেড হয়ে যায়, নেক্সট হিয়ারিংয়ে ডেটে সেটাকে পাঠিয়ে দেওয়া হয়, সেটা হচ্ছে 28শে নভেম্বর। 24শে নভেম্বর সুপ্রিম কোর্টের রায় হবে, তারপর 28 তারিখে কিন্তু সেই ক্যান্সেলের ব্যাপারে বাকি আর্গুমেন্ট কিন্তু হাইকোর্ট শুনবে। যদি ক্যান্সেল ঠিক আছে, সেটা ইয়েস যদি হয়, তারপর বাকি যে যারা পিটিশনার আছে তাদের বক্তব্য কিন্তু হাইকোর্ট শুনবে, কিন্তু সেটা সুপ্রিম কোর্টের রায়ের পর। যেহেতু সেম ম্যাটার পেন্ডিং আছে, সেখানে কিন্তু হাইকোর্ট কোনো মানে এখানে ইন্টারফেয়ার করতে পারে না বলে অমৃত সিনহা এটাকে পোস্টপন করে দিয়েছে 28শে নভেম্বর। 24শে নভেম্বর সুপ্রিম কোর্টের রায়ের পর। আর যেটা ছিল যে 10 নম্বর আগে না পরে, সেইটা নিয়ে অনেকক্ষণ প্রায় 2 ঘন্টা এখানে কিন্তু বিভিন্ন আইনজীবীর কিন্তু আর্গুমেন্ট শুনলাম। সেখানে কিন্তু যেটা বোঝা গেল, মানে আলটিমেটলি কোনো কনক্লুশনে মানে আসেননি। তিনি যেটা বলতে চেয়েছেন যে দেখা যাক 24 তারিখে সুপ্রিম কোর্ট কী রায় দেয়। যদি নো হয়ে যায় তাহলে আগে না পরে তার কোনো গল্পই আসবে না, যদি ইয়েস হয় তাহলে এই সমস্ত আর্গুমেন্ট রেকর্ডেড থাকলো। তারপরে 28 তারিখে যে রায়টা হবে সেখানে কিন্তু বাকি ফাইনাল জাজমেন্ট কিন্তু এই হাইকোর্টের মাননীয় বিচারপতি অমৃতা সিনহা দ্বারা দেওয়া হবে। ঠিক আছে, তো এখনই কিন্তু কিছু ফাইনালাইজ হয়নি 10 মার্কস আগে না পরে। তিনি এটাও মাঝে জানতে চাইলেন যে ইন্টারভিউ যে লিস্ট সেটা মোটামুটি কত নাগাদ আসতে চলেছে। তো যেখানে এসএসসির তরফ থেকে যারা আইনজীবী ছিলেন তারা মোটামুটি একটা টেন্টেটিভ ডেট বললেন যে 17th হয়তো লিস্ট আসতে পারে। তো যাই হোক, তো ফাইনাল এখনও জাজমেন্ট পাবলিশ হয়নি, ফাইনাল জাজমেন্ট এলে পুরো ব্যাপারটা ক্লিয়ার হবে। তবু যতটুকু মানে পুরো মানে ইয়েটা দেখে জানা গেল, মানে যে বিচার প্রক্রিয়াটা চললো সেটা শুনে বিভিন্ন উকিলদের আর্গুমেন্ট, আইনজীবীদের আর্গুমেন্ট শুনে যেটা বোঝা গেল, হয়তো বা টিচিং এক্সপিরিয়েন্সের মার্কস এখনই অ্যাড হয়তো হতে দেওয়া হবে না। 24 তারিখে সুপ্রিম কোর্টের রায়ের উপর ডিপেন্ড করবে বাকিটা কী হবে। এবং বাকি হাইকোর্টের যেটা রায় সেটাও 24 তারিখের পর 28 তারিখেই এই টিচিং এক্সপিরিয়েন্স আগে পরে সেটাও হয়তো বা সেদিনই ফাইনালাইজ হবে। তো ফাইনাল রায় এখন আপলোড হওয়ার পরেই জানা যাবে অ্যাকচুয়ালি কী রায়টা হতে চলেছে। কারণ এরপরে এই দিন বলেছিলাম যে আরও অনেক কটা কেস আছে, সেগুলো সব কিছু ফাইনালাইজ হওয়ার পরই হয়তো রায়টা তিনি দেবেন। তো আরও বললাম যে 11, 12 এবং 9, 10 ইন সার্ভিসদের যেটা ছিল যে 11, 9, 10 যারা ইন সার্ভিস তারা 11, 12 যেন 10 মার্কস না পায়, বা আরও অনেক কিছু কেস যেগুলো আছে। বা আজকেই একটা কেস আছে যেটা মাননীয় বিচারপতি ফিরদৌস সামির আন্ডারে আছে, যেটা হচ্ছে যে যারা প্রাইভেট স্কুল টিচার তারা এক্সপিরিয়েন্সের মার্কস পাওয়ার জন্য কিন্তু এখানে পিটিশন করেছেন, সেই কেসটাও আজকে শোনা হবে। তো এরকম অনেক কিন্তু কেস এখানে আছে, সেগুলো সবই শোনার পর হয়তো আমরা আলটিমেট যেটা শুনানি সেটা পাবো। তো যেটা বোঝা গেল মোটামুটির উপরে সেটা হচ্ছে যে এখানে কিন্তু যারা ইন সার্ভিসদের আইনজীবী বা যারা এসএসসির তরফ থেকে আইনজীবী ছিলেন বা মধ্যশিক্ষা পরিষদের আইনজীবী, তারা কিন্তু প্রচুর জোর একটা কিন্তু এখানে আর্গুমেন্ট করেছেন যে টিচিং এক্সপিরিয়েন্সটা ইন্টারভিউয়ের আগেই অ্যাড করার জন্যে, ঠিক আছে। এবং আমাদের ফ্রেশারদের যারা আইনজীবী ছিলেন বিকাশ রঞ্জন ভট্টাচার্য বা সুদীপ্ত সেন দাশগুপ্ত, তারাও কিন্তু এখানে আর্গুমেন্ট করেছেন। কিন্তু আলটিমেট দেখা যাক যে ফাইনাল যে জাজমেন্ট সেখানে কি বলা হচ্ছে। তো যেটা বোঝা গেল, মনে হচ্ছে না যে এটা এখনই যে এক্সপিরিয়েন্স হয়তো যে বা 24 তারিখের পরেই হয়তো যে এক্সপিরিয়েন্স সহ যদিও হয় বা এক্সপিরিয়েন্স বাদই হোক, ইন্টারভিউ যে লিস্ট সেটা হয়তো বা 28 তারিখ বা 24 তারিখের পরেই কেস মেটার পরেই হয়তো দিতে হতে পারে। এখনই কিন্তু ফাইনাল কিছু করতে পারবে না স্কুল সার্ভিস কমিশন, যতটা বোঝা গেল, ঠিক আছে। তো বাকি ডিটেলস সমস্ত আমরা ভিডিওতে অ্যাটাচ করে দিয়েছি, আপনারা পুরো ডিটেলসে এই জাজমেন্টটা দেখুন, তাহলে ব্যাপারটা আরও ভালো করে বুঝতে পারবেন। তো এটাই জানানো ছিল আজকে ভিডিও অবধি, ধন্যবাদ।
This is regarding the stage as to when the marks is to be added.
The interpretation of rules.
But then will we go into this? Let the court decide, Supreme Court, as to whether the 10 marks will be allotted or not. If it is not allotted or allotted, then...
But no, the problem is that in the meantime, what they are trying to do, they will not get these the favored students again selected, and publish the result, making and shouting that this has become infructuous. Therefore, there are two prongs of attacks. One is constitutionality, it remains. Even after 10 years, it can be declared otherwise.
Yes.
But here, Milord, assuming that the rules are valid, what should be the interpretation?
What should be the stage? Yes.
Kindly come to Milord. It's not about success.
No, successful or not is different.
But I am a Milord fresh candidate.
14,000 only 100. 22,000 open to market. Why Mr. Bhattacharya is thinking?
Why should
No,
I give
if
40,000?
22,000 is there,
Yes.
then why this 10 marks?
No, 8 marks is.
When will you add?
What experience?
When will you add?
I am ready.
When will you add?
I will get it before interview.
Before the interview.
Who says? I will get it before the
Before the interview.
That cannot be done.
It has to be done prior to the
First of
declaration
all,
of the
Milord-
final merit list.
Milord, and second question would come whether, Milord, these after the Supreme Court judgment, Milord, whether they can be treated as, Milord, qualified teacher,
Qualified teacher.
because they have the benefit of trying to get the benefit of experience,
Yes.
and after the appointments having declared void, whether they can be said to be qualified teachers.
That means the 10 marks issue comes in. Right?
10
10
marks.
marks.
But one is, Milord, 10 marks cannot at all be allotted, irrespective of who is there. Here, Milord, if I take the rules does not permit the tainted in the sense, as the Supreme Court said, whose appointments are declared void by the court. I have made similar judgment in other cases also. Therefore, we are sticking to the interpretation of the rules. And I'm inviting my Lord to deal with this.
No, what will be the, what answer do you want that the 10 marks can be given to the past, for the past teaching experience or the stage?
So, two issues are here. First of all, if at all 10 marks can
Is
be given, then
At what stage?
At what stage?
Right.
Second, Milord, the 10 marks can be given, Milord, to the teachers having the experience, past experience. What
Whether the candidates who participated in the earlier recruitment process
would
will
be,
get
could
the
be taken as a
eligible.
past experience. That's the point. But kindly come to the rules straight away. Milord, the
Just one. If we have only one point, adding earlier or adding later, that can
This is what his submission is.
not be allocated to that.
no, I don't say I could be allotted, but not to the teachers who have no experience in the eye of law.
No.
Yes. Well, let me, whole difficulty, Milord, I am gagged. Let me speak out.
Let this hearing be done one by one.
Let us start. Milord, no. Milord, let me please it. I will be happy to be
Wait.
wrong.
Wait.
I don't claim that I am always right, but let me speak out. Milord, kindly come to the rules at page 26. Milord, kindly come to 2K. Interview list. In respect of the state level selection test, means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score. Therefore, the determining factor is preliminary merit score. And what is preliminary merit score? That is score from written test and TET and academic score in the ratio of so and so. Therefore, at this stage of preliminary merit ranking, only thing could be taken note of is the academic score and the TET, nothing else. What the written test, academic score, written test, academic score, and TET. There's no doubt about it. Then merit list. Merit list is a subsequent stage. In respect of the SLST, means in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean in addition to what has been stated in Rule 21K, marks obtained in oral interview, lecture demonstration, and prior teaching. Therefore, the prior teaching, lecture demonstration, oral interview comes while preparing final merit list. After the interview is over. If this is the rule, which is very categorically clear, the question of 10 marks, which is prior teaching experience, will come at the stage of preparation of the final merit list, not at the stage of preparation of preliminary merit list. And kindly now turn to the schedule at page 36. Schedule 1 is the academic qualification, including professional qualifications. My lord, will find what is meant by academic qualification, educational qualification. This is for 9-10.
Shopping at rupees 2000 and SIP at just rupees 100.
Is defined in Schedule 1. Now kindly turn to Schedule 2. This is selection to the post of assistant teacher. Now, 9-10 shall be made on the basis of marks obtained in written examination, educational qualification and prior teaching experience, oral interview and lecture demonstration, which in fact resonate with the definition of merit list. There the academics, educational qualification 10 marks, percentage wise. This is really, my lord, a level playing field. Now the latest judgment of the Supreme Court, I say, delivered by Justice Dipankar Datta on recruitment, says the level playing field is the sole consideration to comply Article 14-16. Then the prior teaching experience. The prior teaching experience, you wanted to bring under educational qualification, which really contradicts Schedule 1. And also contradicts your main rule. The schedule of a rule cannot go contrary to the main part of the rule. And if you follow this interview list and merit list, then there is no doubt that so-called addition of 10 marks can be offered only at this stage of merit fixation, not at this stage of preliminary screening of interview. Why this is being done? Then I have to go to as I say, this is a malice in law. You are trying to do it because 2016 rules doesn't provide these things. This you are trying to do only to accommodate the persons who have been found to be illegally appointed because of entire corrupt practice. And now again, everybody will say, how do you say this? Kindly come to the judgment of the division bench I am referring to. Kindly come to the judgment of the Honorable Supreme Court and subsequent clarification by the Supreme Court itself. Page 130, the delay and latches goes, then kindly come to conclusion, page 131. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who were appointed must be terminated.
I will request you not to place this now. Let us only decide this issue. At what stage the 10 marks will be given? Interview list or the merit list? Only this. And the other issue that you are raising, whether they will at all be entitled to the 10 marks or not, that I'll keep it open for the time being.
Very well.
Only this portion, this stage.
I will not concede to the observation of court.
Yes, because this will be to some extent touching the other issue that is there before the Supreme Court. Let us see how things proceed.
Now, therefore, so far the at what stage 10 marks can be allotted, Milord?
Yes, I get it. No, there are some other petitioners you will answer in the same go. Academics, you said on the last occasion, there is an S which includes a plural. Here it cannot be done.
This one thing.
One.
And second thing I argued, which has not gone down to the order, Milord, that interview list, my senior has already placed the definition. Merit list definition, last occasion I had shown to Lordship that this is these marks to be calculated at the time of preparation of merit list is in addition to the marks given in 2K, 1K. Therefore, this marks, total marks is 100. If they give teaching experience at the interview list level, then the total marks would be 110. Because 2K
Twice you added.
It must be, otherwise they are saying, according to the commission, these 10 marks should be given at interview level. Now, Mlad, kindly
According
read.
to the commission, the preliminary merit list will contain the 10 marks
No,
because
kindly
that is
read.
in the academics.
Kindly read this in this way, Mlad. Means, merit list means, in case of post, a list of candidates prepared category wise on the basis of merit, which shall mean, in addition to what has been stated in 2K.
Hmm.
Therefore, if they give 10 marks of teaching experience in 2K level, then
Cannot give it in L.
then it states marks obtained in oral interview, lecture demonstration, and teaching experience. Therefore, teaching experience they are in any event giving at the time of merit list, in addition to what is there in 2K. Therefore, this teaching experience cannot be given twice. That's my point. And Milad, last question I've submitted that if this 10 marks is given, this rather teaching experience of secondary level is made applicable for senior secondary, then there will be nobody from the freshers who will get chance.
That on the next day. That on the next day.
But this is again on not on validity, Milad.
No.
That you will show the record in the
It will to some extent touch the validity issue because here the those who were there, whether they'll be entitled to get that or not, will be an issue.
16 candidates,
Yes.
as illustrated pages. Milad, I have prepared a supplementary affidavit, Milad, to bring on record Sarfaraz order of Supreme Court, Milad. Though you will assist
Sit.
only at order of Supreme Court actually next, Milad.
Order of the Supreme Court?
Yes.
Which order?
Milad, this is again touching to the Milad, page 10, only for the purpose of page 10, Milad, second paragraph.
17th April.
Milad,
This is
page
there.
10, second paragraph.
Yes.
Page 10, second paragraph. Only for this. Only for this. Oh, that's all.
Freshers. They are also freshers.
May I?
Sir, I have heard you on the last occasion.
No, no,
Nothing
but
more.
after you have to hear me on this.
Yes, yes.
That's I'll at the end I should submit. Let them submit.
No, no, I have heard your submission.
No, not hard on me on this. Now new argument has been made.
No, not a single new point has been raised today. All old ones. Same point.
No, but they have want to hear to know what that's the matter.
Yes, yes,
No.
please. Yes.
Kullan, just a second. Suppose I missed you. In support of my submission, I just have one judgment. Mr. Banerjee will definitely deal with that. 2011 7 SCC. 2011 7 SCC. Page 789. About
Is it there in the compilation that has been
Yes.
filed today?
Yes.
আগেকার compilation টা দেখি একটু spiral binding.
Page 789.
Spiral binding. What is there in the judgment?
That the schedule of a rule must be in consonance with the rules and statutes.
Well, now that's a separate spiral binding. Give me the citation so that I can take note.
Citation টা স্যার
The Joseph compilation.
1K.
Taken in 2011 7 SCC page 789.
রাখুন।
আমাকে শুনতে
শুনে
চাই।
নিয়েছে, আপনার
হ্যাঁ?
কথা শুনে নিয়েছে আর নতুন শুনবে কি?
ভুল ভাল শুনেছে আমি তো
সেই জন্য শুনবে না, দেখবে সব
called on merit for oral interview and etc. Category wise on the basis of preliminary score that is scored from the and and academic. Then the academic score is within the rules, statute. The difference between tests, then take for upper primary and academic. So what is an academic? That has been said, mother, to academic
Page
এটাই তো দেখা
36. Yes, the schedule. Schedule.
One is educational qualification, 10 marks. Then no rounding of our prior teaching experience, 10.
এই তো দেখেছি দেখে আছে আমার এইটাই তো এইটাই ইয়ে করতে জানি ওটা তো
Another heading academic. Then come back again, my love. Again to the loss of the point, then preliminary merit score, written test, gate, and academic score. This is for the part of the interview. Who interviewed this will say who will be interviewed, list of that. This part. Now let kindly come to L. Merit list in respect of the SLST means in case of post, a list of candidates prepared category wise on the basis of merit. It shall be in addition to what has been stated in Group 1K. Marks obtained in oral interview, lecture demo, and prior teaching assistance and track include all the achievements.
So does it mean the submission is that you will add the prior teaching experience twice?
No.
This is what is mean.
No. That is super harmonious construction. That
Right.
not be added.
You are the commission.
I am not a rule maker. I am the commission.
You are the commission, right? Whether this 10 mark is given at the time of interview or at the time of final merit list, it doesn't bother either the state or the commission.
No, but we are working on that now.
You are working,
I have
right?
to make the submission.
Yes,
I have to implement the rule.
yes.
I have to implement the rule.
Mm.
Now, this is practically, this is not correct. That academic, it has been more specified. It has been oral interview, lecture, kindly see. Why is it? See, whether academic score in the score transfer and merit list means in case of post, a list of candidates on the basis of merit. So means in addition to what has been stated in Group 8, marks obtained in oral interview.
What does this mean? That means there is a separate mark in 2K, and then with what you get in 2K, you add up oral interview, lecture demonstration, prior teaching experience.
Will not be added twice.
This is what is mentioned in the.
Your losses can record that the practicing will not count for twice.
No, but this is what the state government rule says.
Now your losses kindly come. Let's say make an harmonious construction.
Let us make an harmonious construction, and whatever is there in the rule itself. Why will you jump steps? The L, let us read L. Merit list, please read once again.
Merit list in respect of the SLST state selection case. In the case of post, a list of candidates prepared category wise on the basis of merit. We shall mean in addition to what has been stated in the rule, the marks obtained in
Right. So 2K, there is a mark fixed, allotted. With that, you add up oral interview, lecture demonstration, prior teaching experience.
prior teaching experience already has been taken.
Then why will it be repeated twice?
Teaching experience repeated, this is a redundant one. There is a redundant.
Oh,
No. Not be given. Now the read the kind of thing.
কোনটাও দেখাচ্ছে কোনটা
Who will
yes.
ডেফিনিশন
advertisement state 11A. See, the central commission Central Commission
একে দেখি এটা তো মেন শেষ করে তো
called for interest. An eligible category on the basis of the preliminary merit score as defined in 2K in the ratio of 1.6 of final result.
There is nothing mentioned about the prior experience in this 8 that you read out.
No, not here, but I say that 2K and 11 Romani. Mulad, while interpreting 2K and 8, Mulad, this course cannot ignore 11 8.
No question of ignoring.
Taken into consideration.
Yes. All right.
Everybody, now Mulad, kindly, this is the judgment.
আমি তো বলছি তাহলে কেন আর দরকার কি আছে আমার?
This is judgment.
ওকে শুনতে চাইছে না ঝামেলা করবো তো?
Yes. Hmm.
102 SSC, 2002 102 SSC, T1E. Kindly come to paragraph 11.
What is there, please say?
The interpretation to section 3 as noticed therein before offered by the High Court cannot be possible by adopting neither the statutes can be read in the manner and fashion evidence were done by the High Court. Appointment of the competent authority in terms of the carrying out purpose of the act indicate the authority is administrative and neither judicial and social. The statutes shall have to be considered in its entire and picking up of one word and from one particular provision, thereby analyzing in a manner contrary to statement of objection, this is neither permissible nor warranted. There are certain fixed canons of construction and interpretation of statutes and the High Court finding as regards the office of the competent authority influence. But this is a principle. Now, another one judgment. But then my submission would be that to this limit, that it has to be read, it will be done. It will be on the basis when the intent list will be prepared.
All right. Yes.
Not 5 minutes.
Yeah.
That is clear.
Yes.
When we interpret a rule, the first thing we have find out that there is no challenge to it. First, if there is a challenge to the rule, then the parameters are completely different. Whether it exceeds the legislative power.
Please do not make this submission. That is not the issue.
Now, today, my lord, your lordship is invited to look into or adjudicate as to at what stage the marks for prior teaching experience are to be given. Number one is prior teaching experience. You need to look into the object of inserting a prior teaching experience as one of the qualifications. And where a rule also permits people who do not have the prior teaching experience to participate or offer their candidature selection process, obviously they are in a separate company. So prior, it's not like the promotional rules from post A to post B. You must have say prior teaching experience of say 5 years. Which applies to all the candidates.
Merit cum seniority, seniority cum merit.
Now, here is a case where your lordship will find two categories of person offering their candidature in the same process. And prior teaching experience fetches a few more marks to the persons who have the prior. The purpose is, what would be the purpose? Because your lordship is dealing with a rule will not emphasize this, will not effectuates the broader aspect that is Article 21 of the Constitution. Because this rule is confined to the upper primary level of classes, that is classes 5 to 8. Today Article 21 fundamental. Therefore, my lord, these rules are what we.
Sir, why don't you sit? Please
But
give him
there's
a
no
chair.
place to sit.
হ্যাঁ, কে বলছে?
But I can sit on the lap of it. Lap of.
He doesn't want to sit.
No, no.
He says,
Sir,
I'm a
please
permanent
sit.
standing councillor.
Please give him a seat.
হ্যাঁ, সিটেই আছে।
No,
আছে, আপনার
no, please.
I was.
Sir, it will be very improper if you stand. Please sit.
Yes.
Please sit.
আপনার জন্য সিট নেবেন হয় নাকি?
কিছু না কিছু না জায়গা নেই। আমার বিকাশে কোলে বসতে হতো আমার।
Now, my lord, the dominant aspect or the broader aspect or the more important aspect, my lord, is what, my lord, we all lose sight of. Is this rule framed only for the purpose of selection, or it has a larger aspect in it, embedded in it, which is to offer or effectuate the fundamental rights of children between 6 to 14. And Article 21 and the follow-up legislation, that is the Right to Education Act, Millard provides that quality education has to be provided to those children of that age group. Now, please keep, Millard, these two aspects in mind, Millard, for the purpose of interpreting the juncture at which, Millard, this prior teaching experience marks are to be awarded. First is, what is the purpose of inserting this kind of a clause? The purpose can be nothing else than to, Millard, provide or ensure that better quality candidates are selected. Now, how do you distinguish broadly? Inter-se merit is something different. But broadly, we distinguish between, for example, take a Millard hypothetical case, not related to this matter. But in a case where, Millard, say one group high secondary candidates, past candidates apply, and another group, Millard, secondary candidates apply. There, Millard, logically, Millard, if somebody says that no, I will consider the high secondary examinees or past candidates as better or in a higher pedestal than the secondary candidates, but that, in my very respectful submission, is a logical approach. But merit-wise, maybe, Millard, the secondary candidates may outshine the high secondary past candidates. So, therefore, the purpose of providing this clause is to ensure that more experienced persons or persons who have teaching experiences are put in a better place for the purpose of selection. Why? Why is this incorporation? To ensure that better teachers are tried to be made available. Finally, who's good, who's bad is again something a matter of perception, performance, many other unknown things. So this being the purpose, now, Millard, kindly read the rules. But we cannot read this rule only to confine it to selection or confine it between the inter-se merits between the prior and persons having teaching experience and persons not having teaching experience. Now, please take, Millard, 2K, I'm sorry. But your lordship must have read this rule many times. Now, interview list means etc. in the post of so and so, a list of candidates to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score. So when I call people, I first prepare a preliminary merit score. Now I have to distinguish here.
With Upstock's margin trading facility, 4x the power, same capital, up to 1.
To distinguish between the more experienced, I call it the preliminary, teaching experience people, and the others who do not have the teaching experience. Therefore, Millard, at the preliminary score assessment stage, I have to take into consideration the merits of those persons, or I have to take into account those persons who have the prior teaching experience. Now, why I say this? Because what is the purpose? You have to look into the purpose also, because
No,
ju-
you are going around the same thing
Yes.
all over again.
yes,
What is the stage? 10 marks, we take it that yes, you can give, because right now we are taking it to 2025 rules as a whole, assuming that it is all right. Challenges before the Supreme Court. This is not the issue here. The court is not deciding at what stage will this 10 mark come.
preliminary merit score.
Yes. Where from are you getting that the 10 has to be added earlier and not later?
Please take rule number 6.
Rule number 6.
Yes, your lordship must have been taken through Miller these.
No, 6.
Yes, I'll come to the schedule. I'll come to the schedule.
No, it's all right. Rule number
Yes.
6.
Rule number 6 says manner of selection. Selection shall be made category wise on the basis of merit in the manner as specified in part A of schedule 2. Now let us come to Miller part A of schedule 2,
Yes.
which is page 89.
Yes.
Miller, schedule 2 part A has Miller 4 parts. All these Miller, the first part is written examination, which is based on OMR sheet marks. Then 2 is academics. Now this academics Miller has been divided into 2 parts. That is educational qualification 10 marks and prior teaching experience 10 marks. Those who are not having prior teaching experience, for them B doesn't apply. Then is the oral interview and then the lecture demonstration. Now, Millard, based on this, Millard, prior teaching experience is part of the educational qualification which is provided under the rules. Therefore, prior teaching experience marks is part of the academic marks that a person is to have.
How do you say that it is provided within the group broadhead academics?
Yes, Millard, 1 is written examination.
Yes.
2 is academics. Now, what is academic? Academic has 2 parts. These 2 parts are applicable in respect of 2 categories of person. If a person has prior teaching experience, then into A and B applies.
Submission has been made to this extent
Yes.
that the word here in schedule 2 is academics. It's S.
Yes,
S.
yes,
Plural.
yes,
In K,
yes,
it is mentioned only academic. The
Yes.
S is not there. And this S
yes,
considers the teaching experience, which is there in the schedule. It is not there in K.
yes.
So,
But are my
Stage.
learned friends suggesting that this is plural and the other is singular?
right, it
Millard,
is.
Millard, general clauses act, Millard. Singular includes plural, plural
Very well.
includes singular.
If that is to be
Yes.
taken, then K and L will be contradictory.
I'll come to that. I'll come to
Yes,
I'll
please.
come to that. Therefore, let us first clear the air that in academics, is academics only confined to educational qualification, or academics will also include prior teaching experience for
Right.
those who have the experience? Well, my very respectful submission is, unless schedule 2 is challenged on XYZ grounds, the schedule 2 as it is to be read, which means that prior candidates having prior teaching experience has twofold academic qualification, if I may put it broadly, and candidates without teaching experience have only one part of the experience under academics.
All right.
Now,
Now-
kindly come back to rule 2K.
Yes.
But I don't think, academic and academics would make much of a difference. One single alphabet will.
রাহুল বলছে যে এখানে আগে অ্যাডজেক্টিভ ইউজ করেছে আর ওখানে আগে নাউন ইউজ করেছে এখানে
Yes.
অ্যাডজেক্টিভ করলে এটা ভুল হয় ইনটেক এরর হয়ে
I'll hear you. I'll hear you.
Hmm.
Do you also have a seat over there? Please sit. Please sit. Yes.
Now, academic score in clause K is nothing other than the academic score spelled out in schedule 2 part A 2. Let us not go into all these things, whether with S and without S, it at all make any difference.
S means the prior teaching experience.
Yes.
Without S is only the educational score.
But in that case, please consider one thing, Millard. What happens to the persons who do not have the teaching experience?
They don't get the marks.
They don't
either
get
at
the
this
marks.
stage or that
Yes.
stage.
Therefore, the stage is, Millard, when I call them for interview, I have with me the marks which they are also entitled to by virtue of their experience. That is the purpose. If I exclude these people at the threshold by treating everybody equally, yes, at par,
level playing ground. This is the
level playing ground. In my very respectful submission, this may not be applicable universally, because preferential treatment is acknowledged and applied in the service jurisprudence.
Yes. All right, then.
Therefore, Millard, if I give them these trained persons or the experienced persons, I go a bit forward by saying that I give them a preferential treatment by adding their marks at the time of preparation of this preliminary merit score, but I would be respectfully submitting that is not infraction of any of the known principles of our constitution or the law of our country. Therefore, Millard, if a person is experienced, Millard, the experience has to be taken note of before calling them for interview and lecture demonstration. Now, the interpretation should be as I say. Why? Because if I do not give them, because it is said, please look into Millard, the bracket portion. It is clarified, that is, from the written test or TET and academic score. Now, what they are trying to say is that academic and academics are different. Well, with respect, possibly it doesn't make any difference. Yes.
It makes a whole lot of difference.
No.
It makes a whole lot of difference, sir. This is the 10 marks issue is there in many matters. Madam, please sit. Please sit. I'll hear you. And now the stage at which it should be added.
2K. This is my interpretation. Now let us come to 2L.
Yes.
Yes. Merit list in respect of SLST so and so means, in case of post, a list of candidates prepared category wise on the basis of merit, which shall mean, in addition to what has been stated in 21K, marks obtained in oral interview, lecture demonstration and prior teaching experience, and shall include all eligible candidates who have appeared in the interview. Therefore, Millard, the prior teaching experience over at Millard L, Millard, if it is held or if it is interpreted to be at the L stage and not at the K stage, then Millard, it militates against Millard Schedule 2A2. And 6. Where the rule by itself, the purpose of the rule is to give preference to the experienced candidates.
You give preference.
Yes. Therefore,
but then at what stage will you give?
Millard, if I give them preference, I need to give them preference at the first stage or at the earliest stage. Because preference, the word preference itself presupposes that from the very beginning I'm going to separate both the classes.
Resources will not be augmented appropriately.
Yes. But preference cannot be, Millard, at the end. Preference has to be always, Millard, at the beginning.
Do you anticipate any candidate
Yes, Millard,
who did not participate in the 2016 recruitment process to get this 10 marks.
More than 3,000 people have applied.
কতজন
More
করেছে?
than 3,000 of central government and more than 1,000 for the contractual teachers of substantive posts in state government. More than 4,000.
Applied.
3,000 plus 1,000.
3,000 বলছে central government.
Two government and 3,000.
The figures, but I do not know, my lord, whether it will correct or not, but my lord, I am instructed to say
I do not need the exact
Yes, sir.
figures.
approximately 3,000 candidates with prior teaching experience from central government institutions, schools, etc. have applied, and 1,000 from
State government has provided us list of contractual teacher and substantive post of 1,000 teachers.
and contractual teachers
In substantive post
in substantive post in state government institution around 1,000.
applied.
They have
And
applied
the total appointment is around 23,000 or how many?
35.
35,000. All right.
Very well, 35, 35, 36
Mm.
more or less.
Mm.
Therefore, my lord, if I have to give preference, well, there are two ways of interpreting it. What is the purpose? If the purpose is to make available good teachers, I have to give them preference at the beginning. Number two is, as they are arguing that this is creating a class between the two. Yes, we are creating a class.
No, the class is not in this matter.
The other,
Class is in
very
class
well.
is matter.
Then, my lord,
Right. Class
yeah,
is
I don't,
not here.
I don't,
We assume that the rule is all right.
very well.
It is only the stage at which the 10 marks to be allotted is the issue.
First, to make available good teachers for the students.
In that stage also.
Yes.
Stage also you can make available good teachers.
No,
Because you
no.
are adding at any case.
My lord, I am giving a preferential treatment, therefore preference has to be given
At the very first stage.
at
This
the-
is
at the
main
inception.
submission.
at the inception.
That is
If
the
they
submission.
screened out, then what is the
Yeah.
purpose?
My lord, if my lord, the experienced candidates are my lord screened out or my lord,
Why will they be screened out? Because they will get the chance at that level also.
if
Nobody is screened out at the
One is
No,
ratio.
2K stage.
No, no.
Ratio আছে তো।
kindly look into my lord, the interview list.
Yes.
My lord, in the interview list, if my lord, these 3,000 or 4,000 are not there, and they have to wait, my lord.
Why will they not be there? That means their educational qualification score must be less. Otherwise,
No,
they
no,
would
no.
have been there.
My lord, my lord, today, my lord, at the time of framing of the rules, or my lord, at the time of invitation or the advertisement or the employment notification, I do not know anybody's score.
Nobody knows anybody's
Yes,
score.
therefore consider it from the stage or at the stage when my lord,
Yes.
an employment notification has been issued.
Right.
There, nobody is in the fray,
Nobody is in the
nobody has applied.
right.
We do not know the inter se merits of the candidates. At that stage, what should be the appropriate interpretation? Milord, the interpretation should not be, Milord, at the instance of persons who come before the court, invoke the jurisdiction of the court, saying that I don't have the experience, therefore I'll be in the back seat always. That is what is being said. Now consider this, Milord, on two angles. One I have already said for the benefit of the students. The other is at the selection stage, I have to give preference or priority to those persons who are already experienced. The experience factor has to be taken note of at the earliest stage. It may, my lord, even be relegated back to, my lord, from the date of application itself. Because on the date of application itself, there are two, submission of application, or the last date of submission of, you have two sets of people. I can do that at that stage even.
I didn't get this. I didn't get this.
Yeah, I'll tell you, I'll explain it, my lord. I invite applications. 10,000 people apply. All the applications are with me. I have invited two categories of persons. Can I not distinguish between the experienced and non-experienced persons at the very threshold after receipt of the applications? General, I'm speaking of general, hypothetically. Not Milord, connected to this case.
No, when you seek application, you seek application from all.
All.
There, what you say that there will be a distinction between the
No,
candidates having
I will invite applications from all.
open advertisement.
All applies.
Yes.
or two categories of people apply,
Right.
can I not give
Two categories means what?
with teaching experience, without teaching experience?
All right.
Now, at this stage, this is hypothetical, not as
Yes,
per
yes,
this
yes,
rule.
yes.
At that stage, after receipt of application, from that stage itself, my lord, the preferential treatment or the preference starts.
Provided your advertisement specifies so. It has to
I mean,
specify.
advertisement may or may not be. Finally, the rules prevail. In case,
That means the rules, whatever, you should have
Yes,
a
yes,
substantive rule
yes,
according to which
yes.
you can
My
segregate.
reading of the rule is that the teaching experience has to be given at the time of assessment of the preliminary merit score.
All right. Yes, madam.
Just one.
Yeah, just a minute.
Just
You want to make more submission?
Just
No,
1 minute.
but I think Mr.
Just
Bandyopadhyay
one
has
minute,
to-
just one minute, just 1 minute.
I'll hear you.
The 5th August, sorry, I missed it. 5th August, Supreme Court has passed an order in the review petition. In that review petition, the Supreme Court has said the entire selection therefore had to be invalidated to maintain the sanctity of the process of selection, which should be pristine and free of all such infirmity. However, the interest of the appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluded paragraphs of the judgment.
Hmm.
Greatest extent here means that this has to be protected. Experience. Now, this is the experience part is also there.
5th of August?
Pardon?
5th of August.
5th of August. 5th.
The supplementary affidavit has been filed as 5th.
Spiral compilation.
1 minute. 5th of August order is there.
Yes. Page 281.
Good.
It's the spiral compilation. 281. 281.
Which portion did you read?
My lord, this is at paragraph 4.
Paragraph 4.
Paragraph 4, last few lines, above
Yes,
paragraph.
the adverse remarks.
The entire selection, therefore, had to be
The
invalidated.
entire selection. Yes.
Therefore, had to be invalidated to maintain the sanity of the process of selection. We should pristine and free of all such information. However, the interest of the appointed candidates who are untainted were sought to be protected to the greatest extent as possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of the selection process is paramount and necessarily has to be given the highest priority. Last but not the least, the adverse remark made against the authorities concerned who are wholly and solely responsible for the adverse appearances of kind of until were fully warranted and justified. Now, my lord, the protection, this is
whatever is protected is protected. That nothing.
But,
Supreme Court has not given you anything
Supreme Court
else.
here has not been clear, but this
This goes against
this
you rather.
protection to these 10 marks which have been given.
You give protection, but at what stage is the issue now?
Now, may I just take you, my lady, back
Yes.
to Schedule 2.
Schedule 2.
My lady's question on academics and academic score.
Yes.
Singular and plural.
Right.
Now, this is only English grammar. How are you in academics? Means English, math, so on and so forth. What is your academic performance? What is your academic score? That is the only
Tell
distinction.
me one thing. How are you
Yes, madam.
interested in this matter?
No, I am in 4 IAs before you.
Yes.
Untainted candidates.
Maybe.
All of whom have prior experience. Now I'll tell you, I'm answering my lady's second question.
Right.
You see, we all have prior experience. Some of us may have 3 years. Some of us may have 6 years. So inter se in this category, if you even look at the rules, I may get 2 years for 1 year's experience. I may get 6 points for 3 years experience.
Right.
Now, please see. Now, please see. May I just take you back? We are just on interpretation right now, not on merits. We're on interpretation.
Give a copy. Give a copy. There was direction for circulation of.
correction. She is not even a party in
I am in items 9, 10, 11, 12, 14.
In 10, I have made him party.
Who have you served, madam? Who have you served? The councils are here.
There was a direction on the last occasion.
Yes.
Give copies of
Who
the
did you
affidavit of
serve?
service here. Give copies of the affidavit.
Who did you serve? The councils are there. Item 9, who did you serve?
10.
No, item 9.
9 and
Right.
10.
We are in
9
9,
and
10.
10.
They're identical, my lady.
Right, 9
9,
and 10,
10.
who did you serve? If there is no service, then I'm not going to hear you at all. Show me.
This is the service.
Please, onake dekhan.
9 and 10.
9 and 10, check out whether service has been affected or not.
Packet service ko
If not,
9 and
please
10 are
hand over copies. Yes, madam.
Yes. So on points of academics and academic score, because the rule could not have said academic score. It has to, it's a composite. It's just English grammar, my lady, nothing more. Academics has two components. So therefore, Schedule 2.2, the title, has to be academics because there are two components to it. Component 1 is educational qualification. Component 2 is the prior teaching experience. Both these are academics. If you ask my son, for instance, what are your academics like? What's your performance? And of course, he runs away when I ask him this. But it will be more than one. Math, English, PE, so on and so forth. What is your academic performance? What is your academic score? That is a composite. So it is only on English. It is not contradictory. Nothing needs to be read out. That's the first submission. Now please see the second submission. Please go to prior teaching experience, 10 marks. My lady has that, Schedule 2.2. At the secondary level in a government or government aided or government sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or contractual basis. So this could include those who are not part of the 2016 recruitment cycle. This could include those who are part of it. This could include those who are in government teaching positions, or this could include those who are on contractual positions. So
No,
the
it's
net
all
is
right.
very wide.
All said and done.
Yes.
The stage. You get the marks.
Yes.
What stage?
Now the stage. Now please go to Rule 11.
Yes.
Rule 11 makes it clear, and then I'll come back to 2K and 2L. Rule 11, my lady has this.
Yes.
In my compilation, it's 541, but be
I
that
have
as it. Method of SLST for selection of candidates and preparation of the panel. The method for selection of candidates. Now, please turn the page over. Please see the sequencing that happens. Rule 10, this is 11, subclause 10, my lady. Preliminary list of shortlisted candidates, step 1. Thereafter, 11, regional commission shall verify the credentials. So at this point, I have taken the exam. I have given my educational qualifications, which are in academics. Please see, that is in Schedule 2.2, academics. So at this stage, 11, there is a verification of Schedule 2 that is happening. This is step 2. Step 3, 12. The regional commission during document verification in case of any doubt on disability. So any other specified categories, there may be other categories also. Step 4, so 3 continues. This is verification of documents. What documents? Educational qualifications. This is criterion 1 of academics. Now please go to 15. The central commission, a regional commission submits these report to the central commission. The central commission, after we have finished this process of academics, which includes educational.
अगर आपके और मेरी तरह शरण कोई मनी भी आपके बारे में पता होता तो उसकी हालत नहीं होती. फ्लाइट्स, होटल, ये सब
Validated interview list, which shall be published and be forwarded to the interview board. After academics has been assessed, this composite list, step 3, is sent to the interview board. Step 4, the final step. After the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list. This is the final stage. The culmination of 1 to 4 is step 5, which is the merit list, which, my lady, is L. That is the final stage. The rules are harmonious. We may have belabored its explanation, but the rules are in consonance with the steps which the rules provide for. It is in consonance with English grammar, and it is in consonance with the idea that a seminal idea which the Supreme Court has long upheld. It is within executive and legislative domain to fix qualifications. There is no preferential treatment here. We are choosing the best possible teachers. That includes educational qualifications, that includes prior teaching experience, that includes performance in the interview.
Very well.
I have a direct answer for Lordship's
Yes.
question. Well, it will be- my first point is it is absolutely clear when in the rule itself there may not be any requirement of any kind of interpretations. Kindly see first 11 Roman 8. Well, this is the substantive part of the rule. There is a difference between definitions for the purpose of finding out what does it mean and what is to be done. Now, what is to be done at 11.8, kindly look at two things, presence and absence. Presence of K and absence of L. So, 8 equals to, kindly, if I read, the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview. So therefore, pre-interview. So there is no confusion. Subject to verification of credentials, it's not relevant, and eligibility category wise on the basis of, now this is preliminary merit score as defined in rule 8.1a. Lordship conspicuously finds that it's not the definition of merit, that is not there. The definition of interview list, that is incorporated. And Lordship kindly come to straightway schedule itself. When Lordship's query is at what stage, 1 first, 2 second, 3 thereafter, 4, and that's the thing. Kindly follow that the simplest thing, schedule 2, A equals to capital A equals to the entirety what is required to be done. It's not what exactly pre-interview, all. Now 1, 2, 3, 4, kindly come 1, exactly that was the beginning written, done. 2, now 2 has 2 components. 2 has small a and small b. Now kindly see thereafter 3. So chronologically, this 3 for 9, 10 and also for 11, 12, it is coming after 2. If I just say once more, there is a clear chronology under the schedule. 1, 2, 3, 4. Yes, 4 ultimately ends at lecture demonstrations. So there, my lord, the oral interview comes as 3. Whereas the prior teaching is coming under 2. So the question before your lordship is at what stage? It is at the stage of pre-interview because of the 2 reasons. Reason number 1.
When is the interview going to be held? Any idea, Commission?
Well, it has to be after the list is prepared.
That I understand. How soon are you expecting to prepare the interview list?
The verification process will go on for till 17th, 18th. I'll take
Till?
instruction and till 18th. I'll take instruction and
Is it after the 26th
I'll take instructions and
or before that? If the
tentative schedule may not
Advertisement they have given, but
that is not being followed.
that is not being followed.
Assuming the Supreme Court interferes and says that 10 marks will not be there, as was submitted by Mr. Mitra on the last occasion, then the stage issue comes later on.
Stage issue, may I say?
Right.
I'll take instructions.
May I just conclude? My lord, the stage issue can only come if there is any kind of confusion, as was sought to be said.
Now they are raising confusion.
Now they are raising, correct, they are raising. I'm not saying that they are not raising, but once lordship look at from this angle, when it is clearly said as 1, 2, 3, 4, and 3 equals to oral interview, now then lordship has to somehow change this rule. I'm not saying that is impermissible, but that's a different thing altogether. As far as the
You say this is the chronology, they say that is the chronology.
no, I don't say the chronology is the only reason. I say this is the chronology. So the rule itself shows that before oral interview, it has to be calculated, number 1.
Yes.
And the direct answer is the substantive. The substantive says 11.8. I would be only praying before Lordship to see the absence of ill, because their entire submission is on the basis of definition of merit list. That comes later on. Lordship, kindly see that in Roman 8, there is an absence of. So therefore, how interview list has to be made, that is clear. Nobody is required to interpret it. They could have simply said, you also add the M. They have, you also add the L. They have not. So where merit list comes, kindly look at Roman 16. Much after. And if you Lordship kindly take the definition, it would be clear also. The merit list is something which comprises of everything if there is a requirement. It is not a double marking at all. Because for primary, that chronology is different for the prior teaching experience. That's they thought it. Kindly look at my lord, this K. So K is the clear answer. What should be the interview list? Number 1. And that says on the basis of the preliminary merit score. Now, where the preliminary merit score comes, is it before oral or after oral? Schedule 2 is clear. Now, their entire submission, if I take it, is they're banking on L. L equals to merit list. Now, if Lordship kindly see a definition of the L, it is possible to say that there is a some kind of, if I say, contradiction. But that is contradictions in the definition clause, not in the substantive clause. Substantive clause 11 Roman 8 clarifies that this list has to be done on the basis of the K and K only. And in that context, assuming that, my lord, there is a confusion, there is a direct judgment. That this judgment, my lord, takes this part. Kindly take the definition clause 2. This is the kind of rule which begins with 2.1. Kindly take, my lord, 2.1. In these rules,
I'll fix this matter later on. Please come. Heard submissions made on behalf of the parties, including the applicants' interveners at length. Stop. Release the matter once again on 28th of November 2025. Supplementary affidavit filed on behalf of the petitioner in the matter of Rahul Mondal and others
Let them prepare the list, but not for
be taken on record. Stop. Next.
যেটা দিলে তখন না তো রুলস আমি ম্যানেজ
In the last day's order, it has been recorded that the fate of the examination will abide by the result of the writ petition. That order remains. So that order continues. And just wait for the Supreme Court to make any type of interpretation, or if you all can get hold of any one line which says that this court can go into all these things, then with an open mind, the court can decide. Otherwise, it's always playing at the back of the mind that anything will touch that 10 marks.
yes.
Anything, any order passed here will touch that 10 marks issue.
But this issue would never be gone by the Supreme Court.
Suppose the court says that the 10 marks will not be there at all.
That is fundamental.
That is the main thing. Then no question of former, later, now, later.
But if the Supreme Court says,
Right, then this is there and the interim order is also there.
okay, give them that.
10 marks, they can always calculate. Let us
There is
see.
already an order to abide by. There is no reason.
Yes.
And this is not that kind of matter that they can seek a stay of entire proceedings.
Nothing of that sort.
On
Yes.
20th November, one clarification, will my lord hear me or not?
I will certainly hear you.
Then he will.
I have heard you. Today also I have heard you. And I'll hear you on the next day
I
also.
would have avoided all the complications.
You have, sir.
How to read a statute, that's the
Yes.
only question.
Yes, sir.
That's
Next day. Ek minute. 9. Yes, yes.
Very threshold I have also completed. But I think to file an application.
For what? No, sir. You must be filing your intervention application. That is on record. What affidavit will you file? What affidavit will you file? Your application is in your support. What further application will you file? Don't add up documents. All right. Can যতগুলো আছে না allow করে দেন.
My lady, just one
The
small point.
documents to be circulated, did you interveners?
Yes.
What about the copies? Did you get it? Copies?
Yes.
Other cans?
I have not received.
See, somebody
will
has not
please
received.
give
Please
copies.
give.
Can.
Please give.
Don't be stingy on photocopy.
To avoid
Copies.
We are involved in the 4 matters, my lord. All the matters we have solved and I have the evidence of service planning.
See, the court is not concerned with the affidavit.
My lord, any of the matters.
Paper should be there. The court is happy.
Hand
a
over.
question of law.
Copies.
But to avoid further confusion, Lordship can record that this issue does not relate to the constitutional validity, but relates to the applicability of the rules.
Last day's order, what is the issue is clearly recorded. I will not add anything.
My lady, my submissions are for all the cans that I'm appearing in,
I
my
have a
lady.
very ill
So
experience
You
before-
file it today, you file it on the next day, it will be the same thing.
Yeah, so it's the same submissions for all of them. We've got them very briefly for my lady's consideration.
Give it, it is the same thing.
Yeah, it's the same thing in all the cans.
Same order will go down in item number 10.
My lord, only one thing, your lordship is allowing these
9, 10,
applications.
11, 12, 14.
They'll
Then,
let
my
it
lord-
be added because I'm hearing them.
Yes, my lord, only one thing, then department may be directed to amend the cost title because.
cost title amend করে intervene
Right now,
এই হিসেবে
intervener হিসেবে থাকছে
let them remain. Let them remain. They have been allowed to participate in the proceeding.
My lord.
The court has heard them.
Yes.
Right?
My lady, I hope I'll be